Okay, so we're still waiting, and weather-wise, with justification, I'm sure, for one more member. But I'm going to allow us to begin the introduction part of the meeting. Hopefully, she'll make it here in that period of time. If not, then I'll talk to you all again. But at the moment, we're just going to start to get through like the basic stuff, okay? Okay, so we have information from Ms. Hudson saying that she wants to call in, but she can't find the number. So. Right here. Okay, good. Okay, so she's signing in. In the meantime, we're going to begin. Okay, so good evening. Welcome to the Kent County Board of Adjustment meeting for September 16th, 2021. I'm going to call this public hearing to order. When you're ready, will you call the roll, please?
Yes, Mr. Saunders, Mr. Jenkins.
Here.
Mr. Cusick.
Here.
Mr. Crossan.
Here.
Miss Hudson, is she on yet? Miss Denny.
Here.
So we have 4 present, 1 absent, and hopefully 1 about to call in.
Okay,
so we should have a quorum.
Okay, so we're going to continue, and as soon as she's on, we'll be made aware of that. Would you please introduce the staff?
Yes, thank you. Good evening. My name is Scott Blair, and I'm one of the planners here with Kent County Planning Services. Also with me is fellow planner Jamie Fensky to my left, and Mr. Fred Townsend off to the right there will be the board's legal counsel for this evening.
Okay, thank you. At this time, I'm going to ask everyone to rise and pledge allegiance to the flag. Okay, any additions or changes to the agenda?
No, there are none.
Okay, so we'll go ahead and introduce the public hearing. And as soon as we hear from Ms. Hudson, we'll start the testimony. But let's just get through this.
Sure, understood. Good evening, ladies and gentlemen. Again, my name is Scott Blair, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary, and the chairperson of the board has the discretion to allow additional time if deemed necessary. To make a statement tonight, when your application is called, please use one of the podiums at the front of the room. If you are participating online and wish to give testimony, we will unmute your line so you can speak. For the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation by staff of that application. The board will then receive testimony from all those in favor of the application, followed by testimony of anyone who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made at the board's business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call Kent County Planning Department tomorrow between the hours of 8 a.m. and 5 p.m. at 744-2471, or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. However, this notice may not be mailed until after the next scheduled meeting. But if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and future property owners. The public notice of this evening's hearing was published on August 30th in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. This time, we're going to have a statement by our counsel, purpose of which is to let those who are giving testimony this evening have an opportunity to understand what is acceptable as testimony before this particular body. Mr. Townsend? Is his mic on?
Okay, so I have to hold it on? Okay, all right. So the test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. That test considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, this board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, lastly, whether failure to remove the restriction would create an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And it is with this consideration also that the board determines whether the applicant is asking for more relief than is minimally necessary to relieve the asserted difficulty. So generally speaking, the board is not permitted to consider factors other than the 4 I listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the nature of the zoning district, the characteristics of the area, whether requested variances would seriously affect neighboring properties, and fourth, whether the applicant is confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from the presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as this board is not authorized to resolve those disputes. That is my statement.
Thank you, Mr. Townsend. Okay. So at this point,
Ms. Hudson, have you joined a call?
Yes, I'm here.
okay, thank you. So we will add Ms. Hudson to our group, and we definitely do have a quorum. So the other missing member of the board is online. She's taking this meeting from online. So we definitely have a quorum. So when you're ready, let's go.
Okay, so first we have application A-21-29 for Brown. Is there someone present to speak on behalf of this application? Please raise your hand. Thank you. So we have the applicant and property owner is Mr. Brian Brown. His present zoning is RMH, residential manufactured home. The proposed variance is a variance from the 30% maximum impervious surface coverage and the requirement that an unattached accessory structure meet the principal setback requirements to legalize a home occupation. The present use is residential. Proposed use is same with the construction of an accessory structure to be used for a home occupation. It's in Levy Court District 3rd for Mr. Angel. It's located on the west side of North Wilson Avenue, approximately 307 feet southeast of Woodford Street, east of Dover. Here you will see on Exhibit B that they are requesting the variance from the 30% maximum impervious coverage. The existing total property area is 25,264. Permitted impervious coverage of 30% would be 7,580 square feet. The existing total impervious area is 10,730 square feet, which is equivalent to 42.47%. He's proposing an additional 299 square feet with an additional 1.18%, totaling 43.65%. Mr. Brown is also requesting a variance from the requirement that a detached accessory structure be used for a home occupation, meet the principal structure rear setback of 25 feet. He's proposing at 2 feet from the rear property line. Here you will see the front of the home with the paved driveway. Another paved driveway. Looking towards the rear of the property. The rear of the property. You will see the proposed building that has partially been constructed without a permit so far. Front of the property looking down the road. And in the other direction, and the aerial, and a farther out aerial. Sir, if you would like to come forward and state your name and address for the record.
John Gary, 48 The Green, Dover, Delaware.
Mr. Gary's a member of the Delaware Bar and is not asked to give an oath. If his client wishes to speak, he'll be administered the oath.
Thank you.
Thank you, council, members of the board. So, Mr. Brown, present behind me, is asking the Board of Adjustment to grant him a variance of the, initially he was asking for the variance for the impervious surface, as much as most of the impervious surface has been is consistent with blacktop and would be extremely difficult to tear up and take out. The proposed 13 by 23 pole building that he's partially completed and placed on the property, again, is permanently attached at this point. It would be very, very difficult for him to remove that. Now, as I understand it, the board, strike that, the review committee has indicated that they are not opposed to the impervious surface, is that correct?
Do you mean the staff report?
The staff report, yes.
Yeah. So staff says denial of the variance for additional impervious surface and from the required principal structure setback for an accessory building to be utilized for the home occupation. However, staff recommends the board legalize the existing impervious surface on the property.
All right, so as I take it, then the staff report would not be opposed if he just took down the proposed building and left everything as it was.
That's correct.
Is that correct? All right. I don't have a pointer, but if you look at the red building, that's the proposed structure. The one immediately adjacent to that is a wood structure, which was present when Mr. Brown purchased the building. The next one is also a wooden building with blacktop underneath, and that was present on the property when he purchased it. Let's go to the next one. That's a greenhouse with either dirt or gravel underneath of it. It has been taken down. And if you take that down, that's a 20 by 12 building, which would eliminate 240 feet, strike that 240 square feet. And the proposed structure that he is putting up would cover 299 square feet. So he would be increasing the impervious section by 59 square feet. But what he has indicated and what he's proposed to do here is to put in a sink well with gravel and downspouts so that any runoff would not be running off onto the other property, but rather would be running onto his property into like a round basin with gravel. Very better than what he has now on any other property. So we're asking that the board consider those factors and grant him the waiver, grant him the variance that he's placed for the building. Now, with respect to the 25-foot setback, that the property immediately adjacent on the other side, I believe, is Top City, and there's a chain link fence that runs along that area, which was shown in the photographs. We submit that the proposed building has no impact whatsoever to the adjacent business property on Route 13, and in fact is completely consistent with what's already there on the property now. It causes no harm or causes any inconvenience to any of the neighboring residential properties or to the business property, and we would ask the board to grant that variance. Oh, the home occupation. I'm not quite sure how the board defines a home occupation. Basically, what he proposes to do is refinish furniture, or buy furniture, take it home, refinish it, and then take it somewhere else and sell it. It's not a residential, or it's not going to be a retail establishment where people will be coming in and out of the property on a routine daily basis. So to the extent that he's going to make money on the property, I guess you could call it a business, but on the other hand, it really isn't a business. It really isn't a home occupation. So that's all I have.
Okay, where to begin? So, before I go, gentlemen, do you have any questions or comments?
Is the property owner going to speak, or are you just going to speak on his behalf?
Well, we can get to
I don't
that.
normally do this, so
Okay.
I'm a fish out of water. So I mean, if
That's okay. What Mr. Crossan is asking is, when you are done speaking, are we going to hear from the property owner?
I think Mr. Brown is willing to talk and answer any questions.
Okay, so if we have questions of him, then
You
we
want
can
to
ask them.
do that now, or
No, let's begin with his counsel, and then, you know, one of the members feels the need to ask questions of the owner, then we'll go there, okay? Is that okay with you, Mr. Crossan? Yeah. You're good? Okay. Okay. So do we have questions at the moment?
Yes, I do.
Mr. Gu-
Are you aware of the opposition email that Kent County received? And Jamie, can you point to what property that?
I was provided a copy.
So that whole property there.
Mm-hmm.
I was provided a copy from Top City to Jamie Fensky indicating opposition.
You're right.
But there was nothing in the email indicating the nature of the opposition. So
Right, I was just curious. So
I have my own. I have my own theories about that, but
So there's no water runoff currently happening on his property that you're aware of?
I'm sorry. What was the question?
Any water runoff, stormwater runoff that's going into his property currently?
Going on his property.
I'm just asking because
We're
over the impervious cover, so this water is going somewhere.
Right, but before he placed the pavement on his property, he will tell you that there was repeated flooding on all of the neighbors, his property and all of the neighbors' property. And he put in some improvements, including the pavement, and now there's no flooding. It helped the runoff of his property and the neighbor's property, which there's no problem whatsoever with any runoff currently, notwithstanding the fact that he exceeds the impervious guidelines of the county.
And what separates the property of chain link fence? Is there any landscaping at all, or is it just chain link fence?
There's no landscaping between Top City and my client's property. But there was a complaint by my client with Top City as to the way he kept his property. So, I don't want to say that this is tit for tat, but it certainly raises that question.
Absolutely, yep.
Like I said, I got the email, but I don't know, I have no idea what the objections are.
Right, yeah, he doesn't state anything.
The email's short if you'd like to hear it.
The email. I have the email.
Oh, you have, okay.
But I don't
All right.
have the. I assumed that Mr. Shahan was going to be here tonight, and I would hear it personally.
Well, we'll see when it comes to opposition. Okay. Anybody else? So, I have a couple things. Currently, the property is already is over as far as impervious soil goes, and in the staff recommendation, the planner's recommendation, they are asking, number one, I'm sure you're aware, they're suggesting that this be denied, but they're also asking that we, if the board, whatever happens, that we at least approve what is already existing as impervious soil. So I just wanted to make that note. There is a whole lot of concrete there. Yeah. Or asphalt. There's a whole lot of asphalt there. And it's not, from my standpoint, and so I'm not going to speak necessarily for individual members of the board, but it's not about the inconvenience. It's about the code. It's about the county's code, whether there is, you can prove an impractical difficulty that makes us make a decision to go outside of the code to grant the variance. So I realize I'm speaking to a lawyer, and and maybe I'm just speaking for the rest of the people here, but the bottom line, it's not about it's an inconvenience to the Top City guy. It could be that it's really about, fear, because there's a lot of
Did you say fear?
Coverage.
Did you say fear?
I'm sorry?
Did you say fear? I couldn't understand did you say fear? There's a lot of fear?
No, I said there's a lot of soil that is covered, that, already. I didn't say fear.
Okay.
Okay. So he already exceeds what's allowed, and he's asking for yet more. Now, I wanted to go back to, can you show us the picture that just shows the buildings? It's an awful lot of macadam. Okay, can you go forward one from, actually, no, go back to where you were. That's probably about. Looking at the proposed building, and at this point, your testimony is that the greenhouse building, which would be on the far left, is already gone. Thank you. And then the other two green ones that line up against the back of the property are to be removed prior to.
That's not what I said.
Okay.
What I said was that with the proposed building, he's 299 square feet in addition to what he already has. But he's eliminated the greenhouse, which is 240 square feet. And underneath of that is not blacktop, but gravel, which does not count as impervious surface. Correct?
Correct.
Correct, yes.
Okay, so at this point, he's only 59 square foot above and beyond what he already has. Now, notwithstanding that is blacktop and it exceeds the code, it does solve the drainage problem that he had prior. And it's my understanding that he had contacted the county a couple of times about the drainage problem, and nothing could ever be worked out. But he was able to fix it. And it might be that he covered up a lot of dirt, but he fixed the drainage problem. And when I drive through Dover and look at all the blacktop that's being put down in this city and this county, I don't think that what he has done here, notwithstanding the code and the purpose of the code, is causing any damage or difficulty to the residential area.
Well, I'm going to accept that your opinion is that it's not causing any damage to anything, to any.
No, what I'm saying is that what he did solved the drainage problem.
Mm-hmm. You know how blacktops, and I'm just going to say this, you know how blacktop solves a drainage problem, or asphalt, or any non-impervious soil situation? It sends it sends it somewhere else. It doesn't drink the water. It doesn't swallow the water. It doesn't create a basin for the water. It sends it somewhere else.
I'm fully aware of what blacktop does and what concrete does.
And there's plenty of, and I'm going to say this, and I really am not trying to be argumentative, but I'm defending our code. The other thing is there may be a lot of asphalt and impervious soil everywhere all over the county. And the whole point is, and that people put down and nobody even knows until something happens. And I'm going to use the words of my husband, a former Delaware State Trooper, who would say, when somebody said, well, everybody else was speeding, and he would say, did you ever go fishing? Did you catch them all?
That's not my argument.
Okay.
I'm not saying everybody else does it, so he should get away with it. That's not what I said.
Okay, just want to be clear on that. Thank you.
That's mischaracterizing my argument.
Okay, thank you.
Thank
you. I apologize.
But for the fact that he put up a proposed building and the neighbor was upset that he filed a complaint, nobody would have gone out and checked his blacktop because it solved the drainage problem for years. And I don't think in your records you have any complaints of neighbors saying, hey, all the water coming from Brian Brown's property is running onto my property, and you need to do something about it. So the fact of the matter is, what Mr. Brown did with the blacktop solved his immediate problem, even though he went outside the code.
I understand your comment. Thank you. And then the next.
So I guess putting the cart before the horse, what he should have done, and what I would have told him to do, is, hey, don't put down the blacktop yet. Go get your variance and tell them what the problem is. Then get your variance. Then you can put down your blacktop. But he didn't do that. You know, he put the blacktop down, saw this problem, and nobody cared until he started to put up another building.
Can you touch base on why he put up this building without a building permit?
I can't answer that. I mean,
Thank you.
maybe
Well,
maybe someone told him he didn't need one.
We will allow you to come and give us testimony next, Mr. Brown. I can tell that you're trying to interject, so absolutely, we'll do that.
Do you have any other questions, Ms. Denny?
Okay, anybody have any questions? Mr. Townsend?
Mr. Gary, the fourth consideration here, we've talked at some length about whether or not the existing conditions seriously affect neighboring properties, and we've heard from you on that. And perhaps these questions are better put to Mr. Brown, but I'll ask you, and you can defer to Mr. Brown so we hear from him on this. One of the major considerations here for the board is whether Mr. Brown is making normal improvements to the property and whether he has an exceptional practical difficulty that he's confronted with that prohibits him from making these normal improvements. And we can see from the sketch that's on the screen right now, there are a number of buildings on the property already. And I think it would be important for the applicant to indicate why he needs another building and what the existing improvements on the property are there for, and why he needs more impervious coverage than there is already present, why he needs the pavement that's already there, and what these other buildings are devoted to. So you may not be the ideal person to answer that question, but I think that's something the applicant needs to speak to.
He can fully explain the blacktop, and then as I'm sure you noticed, the new building is not only it's a two-story building, so he's got some residential aspects to that building that he can't put in the other two buildings. So I do think that Mr. Brown's comments would be better put to those questions, counsel.
Okay, so then I have one more, and it's probably going to be something that Mr. Brown has to answer, but if we're looking also at a variance on the back from property line, and I'm wondering why that building can't be put on the other property. I mean, it looks like you have a whole field next to the property, or is that not? I mean, that looks like it's his property.
Well, I guess he could have put it there, but it would be more convenient to put it where it was. And I know that there's an issue about whether he follows Kent County setback lines or City of Dover setback lines. And I think Mr. Brown engaged in some self-help with, I think he got two different opinions about where he could put the building. But having looking at the back of his property and seeing the one building that's not even 2 foot off the fence, it was, to put it near enough where he could use it, and it's adjacent to the one building that's already there, he didn't think that he was causing anything out of the line by putting it where it is. And it's a pole building, so those poles are in the ground already. But I think he can answer that question.
Okay.
for you.
Gentlemen, any other questions? Thank you, Mr. Gill.
Thank you.
Mr. Brown, would you like to speak on this application?
Hello, everybody. How you doing?
Please state your name and address for the record and allow our attorney to swear you in.
Okay, my name is Brian Brown. I live at 164 North Wilson Avenue, Dover, Delaware.
Mr. Brown, do you swear or affirm that testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so is there anything you want to say to us before we start asking questions of you?
Okay, let me explain from the get-go. You see where the blacktop is on both sides?
Take your mask off so they can hear.
You see where the blacktop is on both sides of the corner of the house? Corner of my property?
Point.
On the,
Tell them which one's
The gray, are we speaking
yes,
of
on
the gray
street,
areas?
By the street.
Okay.
Those two, yes, one corner and the other corner. There was two 60-foot pine trees there. The day of the hurricane or the tornado that went through Dover, okay, on Scarborough Road, ripped down and went through my neighbor's house, McKinney's, through two branches through my roof, back of my roof. That's why when you took pictures of my house, it got different color shingles, okay? It was a quick fix. But those two trees went down. One leaned up against the telephone pole on this side, which the city of Dover told me I had to remove. The other one went down, tore down my fence and all my property and everything else. Kent County came and they said they'll remove it from the street, but I got to do the rest. But the other one, the city of Dover said I had to remove it. So now all of a sudden I was speaking to them, both sides, and I didn't know where's my property stand, either city of Dover or Kent County. I went through you guys, you said, I live in Kent County, I'm using the city of Dover utilities or whatever, but city of Dover told me, no, you're in the city of Dover. This is your property in the city of Dover. When they built the Dunkin' Donuts, I had received, just like what I'm putting out, to a variance for them. I let it go. I didn't care, you know. I mean, it's an improvement. But the reason why I did that, because my truck was on my driveway. My neighbor's car was across the street. My land goes like this. My truck, middle of the night, slid down my driveway and hit his car. In the morning, I got up. Joe Clark, my neighbor, I said, look, man, I'm sorry, it slid down. My property would flood so bad that you could not park in my driveway because the water would get so heavy that with your tires, you'd have to chip them out to get it out in the wintertime. And the flood, you couldn't, so I had to pull all the way up. Once I put in the blacktop, I had a contractor told me I put in 2 dry wells where the trees are. So the water runoff would go down the street and just suck right, there we go, it would get sucked right underneath the blacktop and go away. My neighbors across the street, Clark's basement, did not flood for 2 years. My basement did not flood. My neighbor, the Donovans, they had a big, huge, beautiful garden. And they sell stuff on the side of the road. That would get flooded out. That didn't flood. They loved me since I did that. It cost me $15,000 to save my property, okay? When I bought it, I didn't understand. I bought it when it was raining. The first heavy rain, you couldn't walk to my front door. You couldn't walk to the driveway. The water was this high. Sat there and froze in the wintertime. I bought a tractor just to bust it up so I could drive through. Okay? I solved the problem. My neighbors loved me. They don't, you know. And now all of a sudden, COVID came. My older sister died. her husband died of COVID. Okay? They own a business in New York. Okay? I built that pole barn because she was married for 15 years. Her second husband left everything in her first wife's name and kids. They told her she had to move in 45 days. She was getting kicked out of her own house there for 15 years. Okay? I built that pole barn, and plus she had the nursery, which I'm taking down the greenhouse. I built the pole barn to save her. I want to move her in my house, use the pole barn, and I have a neighbor, my friend Mark. We could finish the furniture and store it in the pole barn, and she can go to Spence Bazaar and sell it. Okay? I'm moving her here for that. That's why I'm building this. I'm trying to save my family. Okay? That's the reason for that. The blacktop and everything else, I'm not hurting anybody. Okay? I'm just trying to improve my life and my family, trying to save my family. I have pictures here from Top City. The reason why he's opposing me is because, what was it? I think it was this spring, I had my family come for a barbecue. And
Mr. Brown,
We're-
Mr. Brown, I don't think we need to speculate as to why it is there's a letter of
all right,
opposition
well,
in the
anyway,
file.
I'm sorry, but it is what it is. That's what I'm trying to do, everybody. I'm not hurting anybody.
Okay, so let us ask you some questions that'll help us.
Go ahead.
So, does anybody else want to go first? Okay. So my first question is, you have a large piece of property, and I'm now just talking about one of the variance requests, which is the setback from that line. Why there? You have that whole side. Why does it have to be there? Why can't it be further in and over on the other property, which appears to be pretty empty?
Yes, but the reason why I have it there, it's more convenient for myself to work through the buildings, because I attached that to my other building, because there's not going to be no electric in it. The two buildings that were there were grandfathered in when I bought the house. They have electric in it. So I would just run an extension cord to do some work in the pole barn and basically try to save my sister's life. Okay? Basically, that comes down to family. Okay? That's what it comes down to, not codes or anything like this. If you were in the same position I was in, I think you'd do the same thing.
Well, in all honesty, I would, like you, have to follow the code because those are the rules we live by, which is why you're here.
Okay.
So, okay.
I didn't know I needed a code anyway. That's why I had a contractor come, and he started building a pole barn and told me I didn't need a permit because it doesn't have a ground. There's no floor to it. So
you had a licensed
I thought he was
person
licensed.
come here
He was a
and-
fly-by-night. I got burnt on the situation, money-wise, of course.
Okay.
But he built it, and I just, all of a sudden he disappeared. And I'm having once you guys came to my house and stopped me from building, the guy disappeared. All I know is his name is Connor.
Okay.
Tony Connor. That's all I know.
All right. So, okay. Let me.
But I'm trying to do the right thing here.
Okay. Anybody else?
Okay. The cost of taking it down is going to be about $6,000. Okay.
Yeah, it shouldn't have been shouldn't have been begun without a permit.
Well, I understand that, man, but I was taken. Okay, I was taken for granted. I mean, he said he could do me cheap, and the money cheaply. That's where you get what you pay for it. And I got burnt.
Okay.
Simple as that.
Okay, so, Mr. Crossan, do you have something? You seem to be.
Could you put up the photo, the one we have that just barely shows the building that he's, yeah, that. Whoop. So some people put up a shed without a permit or whatever. This is a 2-story building.
Yes.
And number one, I don't see how you're going to have $6,000 to take this down, but that's not the point here. The point is that you mentioned yourself that it was just convenience, for your convenience, the location that you put it in. There are other places you could have put it easily. You very well could have even put an addition to your garage coming in out if you just want to refinish furniture. It's already got the surface underneath it. So there were other options for sure. To build a two-story building without a permit is not good, as you've been told, and as I think you know now. And there again, the 2 feet from the property line. Looking at the Jamie, could you go back to the over? Shows the buildings. Yeah. It looked like the building could have been moved, even the way it is now, it could have been moved forward more towards your house instead of 2 feet from the back of the
Yes,
fence.
it could have. Yes, you're right. You're absolutely right. But first of all, when your inspectors came to my house, okay, first of all, I came here, and when COVID was heavy, I wasn't allowed in the building. I had to drop something off and whatever. But then when I said, look, come to my house. They came to my house, okay, not wearing masks or anything. They just came to my house. They told me I was supposed to be 5 feet away from the property line. 5 feet. This is what they told me. And I have proof of it because I have 2 other witnesses that were in my garage talking with them. Then all of a sudden, you guys are telling me I got to be 25 feet away. Okay? I mean, seriously.
There's a difference between a commercial use.
Well, no, first of all, I don't even know where I stand.
Okay. There's a difference between, I'm going to say, like putting up a shed and putting up a building where it's a commercial use. And it's a business. Repairing furniture, refinishing furniture to take it and sell it elsewhere is a business. And that is according to our code as well in the definitions, okay? All right, so therein lies the difference between setbacks, is how you identify, like, oh, I'm just gonna put up a barn, I'm just gonna put up a shed. Okay, number one. Number two, at this moment, really as a matter of housekeeping, I just want our record to be clear that that this property, and I can see it on the map, but I just want it verbally in the record, this property is within the county limits, as are the surrounding properties.
That is correct. Yes, ma'am, it is within the county.
And so sometimes you're hearing from the city of Dover, but that's because they happen to be the provider of utilities. And then, of course, you've got, Route 13 over on one side. So now, in some instances, your property doesn't back up to it, but in some instances, even DelDOT's involved. But at any rate, so just so we're setting and only trying to housekeeping for this record is that, A, you are in the county. And again, and you're admitting this, you didn't have a permit.
Right.
Because you were under the impression somebody made you think that.
Yes, I was taken for granted. I was,
okay.
Money.
All right, so I just want to have those things just totally in the record.
Yes.
Mr. Crossan, I feel like I interrupted
I was taken as a sucker. What can I tell you?
Okay. And so I just want clarification because I may have misunderstood what you said, but I thought that you said that there was a second story on this pole barn because your sister was going to live there, or what? I mean,
no, it's
nobody's living in it.
Strictly going to be used for furniture, fixing furniture upstairs. I made what you use for a regular barn, because I have a tractor and I got open doors so I could lift up and put stuff in there, storage, front door, barn doors. That's what I have on the front of it. So this way I can just take my tractor, lift up the stuff, store it in there, pull it out, drop it down, take it, finish it up. That's why I got 2 stories. Now, I was also told by either was the city of Dover or whatever, if the building is taller than the other buildings in the area, I'm not allowed to do it. My house is taller than that 2-story building. And so is my neighbor across the street, the Clarks, McKinney's on the side, and Top City behind me.
Okay, so I don't think that there's any, well, let the planner speak. Okay.
Mr. Brown, I believe you and I discussed the height of the building, and we discussed that the maximum height for this building is 20 feet at the mean roof height. It doesn't have anything to do with the other heights of the buildings
Okay,
around
well,
it. It
this is-
only has to do, it cannot exceed the 20 feet at the mean roof height.
I don't think it does. I'm
Okay.
not sure. I don't think it does.
Okay, if it does, then it will be brought up, if it is approved,
I
it
don't
will
think
be
it
brought
does.
up and you'll have to come forward
Because
for
it's-
another variance if it does.
I think it's total maybe 8, 16, probably, possibly maybe 18 feet tall.
Okay.
You know,
Anybody else?
it doesn't have a roof on it. It doesn't have a roof on it anyway, so. but-
Does the applicant want to speak to the uses that are in the other outbuildings on the property and why none of them can be utilized for this purpose?
Oh, I got storage up to yin yang. I'm trying to bring stuff from my sister from New York. All those buildings are full. Full.
Okay.
Okay, all right, okay.
So, for point of clarification, so we've got two issues. We've got the setback, and we've got the impervious section.
Yes, and then the non-permit issue.
So if the staff recommendation was to approve what he already has, then am I correct in assuming that if he was to rip up 60 square foot of blacktop, just be quiet, that the, with respect to the impervious ground surface coverage,
Yes, that is correct.
the building would be
But
fine?
we still need to approve what's existing as well, but yes.
Okay, well, I mean, but I want to take it a piece at a time. Okay. So because it's going to be considered a business, the building has to be 25 feet from the rear property line. Is that what I'm hearing?
That is correct. The standard setback for an accessory structure not used for that purpose would be 5 feet. But once it becomes active as part of a business, that's when the stricter setback comes into play.
So if he doesn't use it for a business, it would meet the qualification.
If it could be an accessory structure not used for the business, correct. Accessory structures have a 5-foot setback, but the difference lies in the purpose or the use of the structure. And the greater setback would be if they're conducting business, noise, dust, odor, whatever, you want to keep it further away from neighboring properties.
So, just as a matter of interpretation, I just want to add, for me, I just want to ask this question. So, because of course I do know the code and I know what you're saying, but I just kind of want it said. So, if he were to take everything he has stored in all those other buildings and just simply use that for storage, then the 5 feet setback would be allowed.
Yes, ma'am. If it's used for only residential
storage.
purposes, then it
And-
only
and-
has a 5-foot setback.
Then it
If
would
he's
have-
using it for that home occupation, then it
Which
has the
makes-
25. Yes,
Okay,
ma'am.
so that's just really housekeeping for clarity. If he took all the other buildings, emptied them into the one building, then the other buildings have met the setback. But this one, because he's going to use it as a home-based business, has by code a different setback. Okay.
Right, but these other buildings were grandfathered in, right? Or they weren't grandfathered because they weren't business. Is that what you're telling me?
That is correct. And once they change their use, then
Then what?
they'd have to meet the stricter setback of 25 feet.
You have to tear them down? Be quiet, Brian. You'd have to tear them down?
No, if he's using a certain building for this home occupation, then it has to meet the 25-foot setback.
All right, so let's say he sells me the property, and I decide I don't like working on the green, I want to work out here, and I move my law office into that building. Are you going to tell me I got to tear the building down and move it 25 feet because it's a business? Is that what you're telling me?
It would have to meet the home occupation setbacks for whatever the use is. His use has to meet the principal setbacks, and yes, it does have to meet the 25-foot setback.
So the county would tell me to take that down my law sign, I couldn't use
I'm
it?
not
We
telling
would
you to
tell you.
take down. You can use it for residential purposes. He can store his stuff in there. The building that he uses for the home occupation has to meet the 25-foot setback.
Yep. Mr. Gary, your a law practice would not be a home occupation. That invites patrons, and so it's not a good example.
We wouldn't permit the use. We wouldn't make you tear it down. We would tell you you could not use it for commercial purposes.
Okay. But if he was to tear that building down and put it out in the middle of that other field, you're telling me it would qualify?
He would have to meet the setbacks, and when you have used that accessory structure, you have to meet the rear structural setback instead of the 5 feet, which is 25 feet in this case in this zoning district.
A moment. What? No, you gotta tell him it. You're gonna have to put that. You have to put that on the record.
So, Mr. Gary, and I think you're probably getting ready to just tell us one more thing, and that's fine. But and I generally am very much more lenient when we have attorneys involved, but we are well over our 10 minutes. I mean, well over. So but I just wanted
I'm
to
just
suggest.
about finished. I think he's withdrawing the request for using it as a home business.
Without doubt. I'm not going to use that.
Can we do that? Can we say we're not going to use it as a home business?
Yeah, well, I mean, we still have to deal with the impervious soil issue.
I understand that.
But
has he applied for an after-the-fact permit for this? I mean, it still have to be permitted.
That was in the letter. Just be quiet.
Okay, but this isn't permitting. This is to get the variance to be used as a home occupation. If that use changes and it meets, you'll still have to get a permit as an accessory structure with no use for a home-based business.
He understands he's got to get the permit as, if the board approves that he doesn't have to tear it down. Yes, he's going to get a building permit as soon as he can get in here.
Jamie, I think you have something to say.
Yes,
Go
ma'am.
right ahead.
Mr. Townsend, so if the request was put in for a home occupation for the 25-foot setback, if he changes it to a residential building, he still will not meet the 5-foot rear setback. Would we need to re-advertise this as a new variance request?
Because the new setback will be 2 feet.
Yeah, I wasn't
Why can't-
anticipating
why-
that question, but that's a good question. Have we given the public proper notice of what it is that we're considering?
If the public is not here to argue about a 25-foot setback, then why would they come for a 2-foot setback? I mean, I don't see why we can't modify our request and hear it out and flush it out right here.
I have an idea. How about we table it to next month, and then we can figure out what's going on and work out all the details and give you guys ample time to figure out what you need to have instead of trying to rush something.
We're not rushing anything. I'm modifying my request to tell the board that it's not a occupation, a business occupation. I don't think it's rushed at all.
I think if the board is inclined to table this, they've got ample reason to do it. If the board's not inclined to table it, then we've got to answer the question as to whether or not due notice is given. And I think it is a reasonable, well, I guess if the...
I'm not opposed to tabling it, Your Honor.
If the board were, or if the public were to be concerned about the location of this building, then the public has noticed that regardless of its use, that it could potentially be permitted in its current location. If the public was aware of the planning office's recommendation that variance related to the rear setback has been recommended for denial, then the public might be of the impression that the proposed building could be located 25 feet away instead of 2 feet away. So I think with that in mind, there is a greater concern for the public's interest than there would be if the situation was reversed. So I think at this point, I think the board has to consider whether they'd like to table this in order to get their arms around, in order for the applicant and the planning office to get their arms around what it is exactly the applicant would like to do, so the board can properly consider what relief the applicant may need.
And not agree more because at this point, it's very confusing, and the other thing is, although it could be online, but not to the best of my knowledge, and we don't know, I guess, until we go to opposition. But obviously, we do have an email from a neighboring property that definitely has some questions, and certainly knew that this meeting was occurring and could be here tonight. But by the same token, if we're changing this request around, I think it's only appropriate to give more time. My question to you would be, obviously, this is just this initial testimony has taken quite a while. Do we table it for the hearing aspect, or do we then just table it for the vote? Get the information, let them organize, report the information to us. What is your suggestion?
If the application is changing significantly, and I think there's a sense that it is, and that it is evolving, then we would need to table the public hearing in order for the final plan to be exposed to the public, so the public knows whether they need to be here or not. Some members, the individual who's expressed opposition could very well show up in support of the application once the application is modified. So.
Okay, so that said, but we should continue to hear opposition, or should we just stop now?
We can ask if there's anyone here in the room who wants to be heard either in further support or opposition, and just get a sense by hands raised whether we want to pause at this point or pause after the public hearing.
Okay. So would you please do that?
Is there anyone else that would like to speak in favor of this application? Is there anyone that would like to speak in opposition of this application? Please come forward one at a time, state your name and address for the record, and allow our attorney to swear you in.
Okay, so let me start with a question for these individuals before they're sworn. I mean, is there opposition to this matter being, or would you be available to come back in a month if this matter were to be tabled and reconsidered a month from now after this application is potentially modified? So you don't feel like your rights to express yourself on this would be aggrieved if we paused at this point and reconvened the public hearing in a month? You're okay. All right. So that would be my recommendation then.
Okay. And gentlemen, I do appreciate that, because I really do feel that this board certainly needs a lot more information before we can go forward. And as that information might change, then you probably would want to be here so you can hear the full, whatever the outcome is, before so when you have your turn to speak, you can address anything new. So thank you for that. So at this point, I am going to look for a motion to table this until, and we won't have to re-advertise, so it could be tabled for next month's meeting.
We're going to have to consider the question of whether this needs to be re-advertised, and it's going to be based in part on the interaction between the planning office and the applicant between now and a month from now. So,
Okay, so at this point, I'm looking for a motion to table it until, for
just
a
a
different
motion to table is all that is necessary.
I'll make a
and
motion.
A date certain is not.
Okay, so we're just going to make a motion and at this point to table it, and you'll be notified, or there'll be notices, just like you were. This meeting tonight was noticed. Okay, thank you again so much. So I'm looking for a motion to table.
I'll make a motion to table application A21-29.
I'll second that motion.
Okay, we have a motion and a second. When you're ready, call the roll.
Okay, Ms. Hudson,
For A-21-29, I vote to table it until next month.
The motion does not specify. That would be adding a condition. So the vote should be either in favor of tabling or opposition to tabling.
Oh, I was just listing the applicant. I was just saying A-21-29. I vote to table it until next month.
No,
Okay, so
don't set a timetable on it. Just say I'm going to table application.
Oh.
Just say yay on the motion or nay on the motion.
Okay, we heard yes, and you're breaking up considerably. So we heard yes.
okay, she said yes to table. Mr. Crossan,
I vote yes to table.
okay, Mr. Jenkins,
I vote yes in support of tabling.
Mr. Kusick,
I vote yes to the motion.
and Mrs. Denny.
I vote yes.
Okay, did I miss anyone? 1, 2, 3, 4. So we, on a motion to table A-21-29, we have 5 yeas and 0 nays.
Okay, so having received unanimous positive votes, A-21-29, Brian F. Brown is tabled until further meeting.
Thank you.
Thank you.
The only question I have, he brought the sign with him per the instructions. Does he take that back and put it back up, or what does he do?
leave it with the security guard out front, please. Not out front.
All right.
Next, we have application A-21-31 for Delaware Electric Cooperative, Inc. Is there someone present that would like to speak on behalf? Thank you. So again, we have applicant and owner Delaware Electric Co-op. Present zoning is AR agricultural residential. The proposed variance is variance from the 40-foot principal front structural setback to build a utility control building. Present use is substation, proposed the same with the utility control building. It's in Levy Court District 5th for Mr. Sweeney, located at the corner of Allendale Road and Fence Post Lane, northwest of Iola. You can see here that the proposed 18 by 20 control house is proposed to be located 29.68 from the front property line. The front building setback is 40 feet. This is looking right on at the property, down the road towards Fence Post, the other direction. Again at the front, where the proposed building is going, from the corner of Fence Post and the aerial. Ma'am, if you would like to come forward and state your name and address for the record and allow our attorney to swear you in.
Dana Dunphy, Century Engineering, 550 Bay Road, Dover.
Ms. Dunphy, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And please proceed.
I'm here to represent Delaware Electric Cooperative. They want to propose a control building to encroach into the front setback due to the fact that the building would be too close to existing equipment that's out there now.
Okay, any questions?
maybe it's obvious to everyone, but I don't really know how the industry works. I mean, can you speak at all to the need for the building?
I cannot. I'm not familiar with what they need it for, just for future electrical uses.
So at this point, you can't address why denying it, what your exceptional practical difficulty to be asking for it in the first place is?
Right, I'm not sure.
We do have an application. I mean, we may not have, an electrical engineer to testify, but we have an application, and I guess it must speak to that. Is that the case?
Their response is, as this is an existing substation use, we don't feel the removal of the restriction would impact any of the surrounding properties. Delaware Electric Cooperative is asking for this variance to place a control house maintaining required setbacks from existing equipment. Failure to maintain the required equipment setbacks could result in dangerous electrical arcing between the equipment and the control building. The control building is required to house a newer electric technology that allows for the remote monitoring and control of the substation.
And that answers my question, that last sentence, so thank you.
So an exceptional practical difficulty created by this arcing, dangerous situation. So, okay. So, anybody else have any questions? So, yes.
Sorry.
Oh, I'm sorry. Sorry. Next. Yeah. Does any? Okay. Sorry.
Is there anyone else that would like to speak in favor of this application?
You can have a seat. Okay.
Is there anyone that would like to speak in opposition of this application? Seeing no one.
Okay. Thank you. Sorry. So at this point, then we're looking for a motion.
Crossing.
I'm sorry, it's not the business
Do we
meeting.
typically do that in the business meeting later? I know we tabled the other one, but yeah, we're not in the business meeting. We're still public hearing.
It's been a long night. I'm sorry.
That last one kind of got us off
Okay.
course
So
there.
let's moving to the next application. Good.
Great, thanks, Ms.
Sorry.
Denny. The next application is A21-32, Frank and Sheila Miskowski. Is there someone here? Mr. Miskowski, we'll call you up after I introduce it, and we'll get some testimony from you. Thank you. Again, this is A21-32, Frank and Sheila Miskowski seek a variance from the 25-foot rear setback and 35% maximum impervious surface coverage to build a shed roof over an existing deck. The property is located on the north side of South High Meadow Court, 180 feet east of Tall Oak Drive, being Lot 225 in the Satterfield subdivision, east of Felton, Livy Court District 6, and Zoning District AC. So you see here in Exhibit B, there's an existing deck, and the Miskowskis want to cover that with a shed roof to, I guess, shade themselves. They can speak to that. But the rear setback is 25 feet, and they're going to be 9 feet. So that's the reason they'll need a distance variance. In addition to that, you can see the existing impervious surface is actually over at this point at 37.8. 35 is what's required by code. And the additional impervious plank decking where water can move through is not considered impervious surface. Once it is covered with a roof, then it becomes impervious. So by covering the existing deck with a shed roof, we'll add impervious surface and bring it to a total of 42% which is over the 35%. Up next, this is the sign posting in front of the Miskowski's house. You can see this is looking down the street in one direction and down the street in the other direction. This is the back. You can kind of see the top of the the deck with the railing there and the caps, and here's a better view of that. And here's again looking at the deck from the back that will be covered with a shed roof. You can see it slopes very steeply at the back. Another picture of that. And this is just an aerial photograph. You can kind of see what's behind it. And a higher up aerial photograph to get some feeling for the character of the area and some perspective on its location. Okay, Mr. Miskowski, if you could come up and allow our attorney to swear you in and give testimony, please.
Name and address, please.
Thank you. Frank Miskowski, 43 South High Meadow Court, Felton, Delaware, in a Satterfield development. You can call me Frank.
Thank you. Do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And I would ask you to raise that microphone a little bit. It's adjustable.
Sorry.
Yep, thank you.
Is that better?
Yeah, much better.
Thank you.
Okay, so now it's your turn to tell us what you're trying to do and why you need the variance.
Well, maybe you could tell me. I'm just trying to put a roof over my existing deck for shade and also protecting the furniture on the deck. It's really hot out where I'm at in Delaware, basically. The trees that are behind my house, which you saw, all the trees back there are about 100 feet tall. And they don't quite reach my property to provide any shade whatsoever. So the deck's sitting in the wide open and a lot of heat goes in there. And the deck gets kind of hot, especially during the summer. Yeah, it's really hot. So that's really what I want to do, is just put a shed roof over it. Your staff denied it for a couple reasons. One was to put a awning up. However, if you put an awning up on a deck in Delaware, with the winds we have in Delaware, and especially my development, and the gusts we have, it would probably rip it off. And it wouldn't last long, and I would put a lot of money into it, and then wouldn't be able to put it back up again. The second thing is the impervious surface. I have no sump pump in my house. I don't have a drain field in my house. I have pretty much a steeper driveway than most of my neighbors, and the backyard is very short. I don't have all of the hill that you saw in the pictures, but that hill is covered with trees. There was a bare hill when I bought the house 4 years ago, but now it's all trees. So there's no erosion issue going on back there because all the trees have taken root back there. There's probably over at least 100 trees that have grown on that hill there. That's really steep. You can't even walk back there. So part of my property is covered by that. So I use my property, my deck, as my backyard. The dogs use the rest of the yard for themselves, but we use the deck for everything. And it'd be nice to be able to have it all year round with shade, protection from the weather, and everything else. And they want me to also put 8 foot. The staff mentioned 8 foot overhang, which would be within the limits. However, to crawl underneath my deck, just shovel it out with a trowel 2 feet deep and run the post up through the deck, which I have to take the deck apart, which is a composite deck, and to go all the way across would interfere with everything I put on the deck. You have all these posts going all the way across the deck, and that just wouldn't be convenient at all. Now, I went 12 feet to put the furniture on there.
Anybody have any questions?
I've just got a couple for you, sir. It looked like from the photos that the staff took, it was raining, and now I'm looking at this particular photograph here, and it looked like it surely was raining. I see water standing there puddling, and I'm not sure what that little, was put up.
I put that up because that slope there where my shed is really steep. I need to build it up more. It's really steep on that side. As a matter of fact, my property ends very close to the end of that thing. So it angles down like that. And the only reason it's there because I did put a drain field in there. There's at least 4 to 6 inches worth of stone underneath there to help drain it away. And I just need to build it up a little bit more.
You can see where the water is definitely going, coming down there. So
right, I do. It's got a cloth underneath of it that the builder put in, and I just added more dirt recently within the past year, and I just didn't get enough in there to help the drainage issue.
So, just back to your comment real quickly about the awning that the staff recommended. We actually have one of those canvas awnings. They're very heavy duty, and they're meant to be rolled in and rolled out, not meant to be left up all the time. Otherwise, it would be a cover over your deck, and the water would go off the same as it would with your shed. But a retractable awning, you let out when you want to be out there, and you take it back in when you don't. So they do work. The other thing I would ask you is 30 feet, I believe it was, along the entire deck.
Right.
So why do you really need 30 feet?
Well, I have furniture along the whole deck. We have bought barrels that we fixed up to put out on the deck, along with that, so to help protect that, because we want to put something on the barrels we bought, and to keep all the cushions from getting wet. Well, I had to take them in all the time, and that way also the dogs will have someplace dry to come up through the house instead of coming in soaking wet. We could actually put carpet down underneath it there, and they could actually end up being dried off before they come in the house. And I have 4 dogs.
Well, the one thing I'll say is in your favor, I believe, is the fact that there is an awful lot of pervious land behind you, obviously. A lot of times we get this situations in developments where there's right behind your house, there'd be a whole nother street, a whole nother row of houses, and it could affect them. In this case, there's really not much to affect. It's going to go down to a stream. But I'm a little concerned about why you really need to cover a whole 30-foot when you could do partial, possibly, but in any event.
But even if it was partial or full extent, it still not meet code, correct?
Right, and you could also put a retractable awning that would give you
Well,
shade.
that retractable, I've seen what retractables do. I've seen them small, and I've seen them large, but we have some pretty heavy gusts of wind in there. And if you happen to forget that one day, you put it out there, and when we have a big storm or something come at night, or hurricane winds come through and you forget you're at work or something, by awning, it's gone. Whereas a permanent structure, it's going to be solid. I'm looking to put a metal roof on it anyway, so that it can slide right off.
Thank you.
Anybody else? Okay, so first of all, I want to ask, can we go back to the previous photograph of the side yard? Okay. Thank you. So that vegetation that we see up against the side of your property, because you described that your property line is just about where that board is. So
actually, it narrows down. It goes from the narrow end right at the shed there, and it drops all the way down to the back on an angle to the bottom of the hill. So a lot of my property back there is in that tree area, down that hill, and to that real big tree in the back there, you see it? That's where my property line ends at.
Is there a stream in there, or is that just purely woods?
There's a stream I'd say about 200 feet back, there's a stream. All the geese hang out back there and all the wild animals.
Okay, so, and on the other side of that, I'm just going to say hedgerow, vegetation, whatever it is, on the other side of that, you have a neighboring property?
Do I have any what?
A neighboring property, a neighbor. Oh, yeah, okay.
My one neighbor, Barbara, here, is right next to me. She's on the right-hand side there. And the one next to me is Eileen. She has a 2-story next to me.
Okay. So essentially, the drainage that we see running from your property is going into that area, and at that end, there is no stream, and you have a neighbor on the other side of that.
The only reason that it's draining wrong there for some reason, and that particular day they took a picture, is because I built a wall up there to help me build up this. So when I mow the grass back there, I don't fall down a hill. So that's why I put the wall up, so I wouldn't have all that, or else you wouldn't see any of that there. I just need to build up more dirt in order to make it even. I already have drainage going into it through the stones I put in there, and to protect it from keeping water there. It's just that one little section, that's it. It's not even that big.
Okay. Okay, I think I've asked all my questions.
Yes.
Mr. Jenkins.
Yes, I have something. What is going on behind you off of the rear of your property line? Is there anything going on back there at all, or is that just woods or?
It's all woods, all wetlands. Everything back that beyond from the hill back. All of it's woods, all of it.
Okay. I have another question. You're requesting, I think, a 30 by
14 max.
a 30 by 14.
Yeah, because I'm putting 6x6s in for the post. So you figure I have a 12-foot deck, 5.5 inches for the post, and just a little bit of overhang, and that's it.
So, what was your reasons for? Could you work with us on a 30 by 8? And if you couldn't, what was the reasons why a 30?
Oh, the 30 by 8, because the deck's already built. I built the deck myself. And it was, I put a lot of time at 2x10s, 6x6s, and I used the composite type material, not wood. It's not screwed in, it's clipped in. I would have to go underneath it. I would have to rip out those boards in order to do that. And that's already clipped in from one board to the next board. And then have to go with a trowel to get under the deck with a hand trowel and try to dig yourself a 2-foot deep hole under each of those to go through the deck, which would then defeat the purpose of having a deck 12 feet because of all these poles being in the middle of it.
Okay, I just was asked because how you might could meet us in the middle here or help us out. So that's why I was asking.
Okay.
Okay, so now I have a question, which is, so you built the deck not intending at any point to put a roof over it, and that's why you didn't get a permit.
Initially, I applied for the permit for the roof, which I knew was going to be denied anyway because it needed a variance. I was told that by the permit office. I did the 12 feet initially, asked for to put a roof over it. I was denied because of the variance required. I already knew that beforehand when I built the deck. Now I'm requesting to do that because I didn't want to hold off putting the deck up until the variance was settled, which would take several months. So I already had the material there, so I said, we'll just build the deck now. And just requesting to put the roof over it, which is only going to cover the deck itself. That's it. And considering the drainage I have in my property, it's not an issue. It drains very well.
So what I'm understanding, and I ask that you correct me if I'm wrong, is that you went and talked to the county about it, and they told you what you were allowed to do, and that what you wanted to do would require a variance, and you just did it anyway?
I built the 12-foot deck because that's what we wanted. My wife and I wanted a 12-foot deck. Give us the room for furniture. 8-foot deck is very small. You can't put much on it. It backs up into because the railings come in about at 6 inches from the end of the deck. The composite railings I have around the deck because of the way it's built. So the railings come in, so that takes away inches in there. Then you take an 8-foot deck itself, you don't have a whole lot of room on there. You may have the length you have on there, and you could put a roof over all that, but the length of it was the width of it was just not there for what we wanted to do. We could have done 10-foot, we could have done 12-foot, but 8-foot was just a little bit too small for us.
And the deck that you built, you submitted and got a permit for that?
Yes, I got the permit. That was all approved, and it was inspected and everything. It was all done. All that was completed. I put a second permit in for the roof, and then the variance went through.
Right, so decks only require a 10-foot setback, and decks do not create impervious, so that's why there wasn't a problem. As soon as it gets covered, the impervious issue and covered are treated with structural setbacks, and that's where that triggered the 25-foot.
No, I figured that with putting a roof on it, it's metal roof, it would actually have a gutter on it too. So I could put a drain down there and drain it off the property without a problem.
Well, a roof is a roof is a roof.
I understand. It's a roof. I'm just talking about the water flying off the roof going down into the dirt.
I guess what I'm trying to understand is you spoke to the county about it. They told you what you would have to do for either event. You decided you wanted it now, and based on what you said, unless I'm misinterpreting, and so you decided to cast fate to the wind pretty much and went ahead and built it at a size that you knew you could change and require you to have a variance. So now you're here asking us, like a mea culpa thing, you know, you're asking us to fix that.
Yes.
Okay. All right. Okay, so I think I'm done with questioning. I just like, for the record, have you seen that the staff recommendation is for this board to deny this?
I saw the staff.
Okay.
I mentioned the staff recommendation when I first started that
Okay.
what they wanted to do, and it's kind of hard to do that at this point.
Okay. Okay, I think that's it for me. Anybody else?
Yeah, I had one. So the concrete patio to the right of it,
It's a brick pavers.
pavers.
Yeah, I put brick pavers down there. My wife wanted that there, so I put a 9-foot by 11-foot brick pavers in.
I mean, any way you could cut some of that out to.
Oh, they can be removed very easily. That's not a problem.
Yeah, I mean that'll be helpful for this board. Like Mr. Jenkins said, just try to meet us halfway somewhere.
Yeah, that's not a problem at all.
That'll be helpful.
There's only like 600 bricks in there.
So what's that square footage?
About 9 foot, 11 foot, approximately that size.
All right, thank you. And then looks like you guys did your due diligence with your neighbors. Got a bunch of signatures from your neighbors.
Yeah, I did it within 200 feet. I think I only missed 3 neighbors out of all of them because ones weren't there. It lives in New York. One was moving, and then the other one he's got the second home in Rehoboth.
And the next door neighbors, are they signed off on it?
All of them signed on except those 3, and I have 2 here.
All right, thank you.
Also, if we go through with this, and you mentioned about putting your gutters up on that, what would be the roof, very possibly if you went down on each end of that and buried a 4-inch or 6-inch pipe under that slope, so it went out into that slope a ways, so it would stop the water from going over. Instead, you'd be taking it out away from your property.
What I've been doing recently, and what the builder has done, is that he put drain pipe in to the ground and then put a pop up in the surface, which I'm doing currently. I'm redoing because they all sunk about this far deep into the ground. So I'm raising them back up again. So I'm adding just 2 more. One on the left side of the house where the shed is. There's one by the shed. I put one in about 8 feet long. And I'm going to put another one in about 4 feet long on the other side of the house. And then the front's already covered with the pop-ups. That's what I was planning to do.
Thank you.
Yes, one additional question and comment. You, at this point, you have not built this roof, correct?
Oh, absolutely not.
Well, let me just comment from my experience on this board. I appreciate you coming here first. A number of times people...
I think I spoke to
People
Scott. I think I spoke to Scott at least 5 times.
My comment was in the past, we see a number of people who actually would have done the roof and then come to us and ask us to clean it up.
Well, if you saw the pictures, I didn't have a roof on there anyway, so yeah, I wouldn't have done it without a permit. I know how it works. If you sell a house without a permit, they can come back and make you take it down.
I'm just thanking you for
I appreciate
following
that.
the steps that you are so far.
I appreciate your help. I really do.
Anybody else? Okay, thank you.
I appreciate your time. Thank you.
Thank you.
Thanks, Mr. Miskowski. Is there anyone else who would like to give testimony in favor of this application? In favor of the application online or in the building, in the room? No? Okay, seeing there's no more testimony in favor, is there any testimony in opposition to this application? Opposition, either in the room or online, Mark? No? Okay, seeing as there's no more testimony, the public hearing for A21-32 is now closed. Thank you.
Next, we have application A-21-33 for Ahmed and Zarul. Is there someone here that would like to speak? Thank you. So we have the present zoning district is AR. The proposed variance is from the 10-foot side setback to build a single-family home. Present use is vacant. Proposed use is a single-family home. It's in the 3rd Levy Court District for Mr. Angel, located on the east side of South Bay Drive, approximately 530 feet south of Kitsumic Road, north of Bowers Beach. The proposed variance is from the 10-foot side setback to build a single-family home. They're requesting the 7-foot on one side and 5.5 feet from the other. Last year, this same property was approved for a 6-foot variance to allow 6-foot building restriction line on each side property line. This variance was granted, but it has since expired. Here you will see right on at the property. Looking farther down the road and down the other direction. And again, right on the property, the aerial, and farther above. Sir, if you would like to come forward, state your name and address for the record, and allow our attorney to swear you in.
Good evening. Youssef Zerwal, 105 South Bay Drive, Dover, Delaware.
Sir, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Proceed with your application.
We are just trying, as stated action letter and documents that you have, we're just trying to build a home for us and the family to live in. We always wanted actually to have a beach house. We've been looking for 2 years, and we actually love the community over here and decided we found the land that we bought. And as stated initially, the variance was approved. It expired only May of this year, and we just had to resubmit for it so we can build a home, because without it, it will be impossible actually to build a livable home in there. And actually, there was the previous home that was destroyed by the previous owner in 2011 did have the variances in there, and so we're just asking actually to reestablish the same thing, which the owner that we bought it from had applied for, because they were planning to build similar home, but I guess COVID changed their plans. They live in North Carolina, and by the time we got the agreement stuff, it expired in May, so we had to reapply.
Okay, so in the staff recommendation report that they give to us, they are asking for a modified approval, which would be back to what was permitted before, which would be that you center the building with 6-foot side back on either side. So instead of 5 and 7, it would be 6. And can you address that? Can you tell us?
Yes, the problem with that is just with what we're trying to accomplish, and also because, like we put, like Soraya put in her letter, we have a grandmother actually that needs a wheelchair. We plan actually to make it as comfortable for her to access the home. With that small variance, that will actually give us more space just to allow for that and have like a nicer hallway while having actually a good sized bathrooms in there and a good sized hallway for her to be able to move safely within the house.
So essentially what you need to have, because of the handicapped accessible issue, you need to have wider hallways, doorway, and a wheelchair ramp or something?
Yes, basically the wheelchair ramp, but also enough of a hallway for her to move freely without having to manage the corners and everything else within the house.
Okay, so the 6-foot on either side is you need 7-foot on one side and then 5.5 on the other.
Yes.
in order to accommodate the ramp on the outside of the building?
What to accommodate
Essentially,
actually
we're concerned
to
with
create.
the outside.
What?
You know,
I'm sorry.
we're concerned with the outside, with the footprint.
Mm-hmm.
And I realize what your testimony is, that you need more space in the house, and so you want to make one side.
Well, that will
Why?
help us accomplish both goals, which is having enough room within the house itself, but also for her, when we're outside, especially on a wheelchair, you want to have like enough room to have kind of like a walkway around the house to get to the front or the back of the house. So that will allow us to accomplish both goals.
Okay, and so essentially, the difference between what's been approved before, 6 on either side, which is 12 feet.
Sure.
You're asking for it to be 12 and a half feet. So you're only asking, for.
Yes, essentially,
half
yes.
a
That's
foot
what it
difference.
is,
Okay.
absolutely.
Okay. Am I wrong?
No, you're right.
Okay. So, and you've already told us why you need to do this. Gentlemen, do you have any questions? Anybody, thoughts, questions?
Yes, I do. What type of structure are we talking about here? Is this going to be stick-built, or is this something that's
This is going to be stick-built, yes. It's actually going to be custom-built, and it's going to be just a two-level home, and it's going to have a rooftop on the top. So the lower area is not going to be livable. Of course, it's going to be stick, and it's going to be parking. That's pretty much it.
Yes, I did have another question in terms of, in the letter that you, I guess, sent to the committee here, you said something about the house being safe, like for your, I think it's your mother, 93?
It's actually our mother.
So do you have any concerns as far as like a fire hazard and the distance from the next nearest neighbor on both sides? If there was any kind of...
The nature of the neighborhood is all the same. Actually, if you look at the aerial view of the neighborhood, you'll see it's all the same. That's how the lots are. Plus, actually, if anything, our home will be less of a risk than the current homes because, like I said, first, it's going to be raised up. And second, even the material that's going to be used on the outside is going to be like cement board, which has less tendency actually to catch on fire than most of the structures that are there, which have either regular wood siding or vinyl siding.
So would it being raised up, does that make the composition of it in character to other houses, or your raised up structure would be different?
I'm sorry, I didn't understand the question. Yeah, no, it's going to be up, yes. Yeah, it's going to be up.
All right.
They're all grandfathered. The ones that are down low are probably grandfathered in.
Correct. To rebuild today, you'd have to meet flood standards. This is a velocity zone, maybe even being right there on the bay, so...
Okay, thank you.
Sure.
Just one more.
Sure.
The house design based on this?
I do. Yes, I do. We do. Yes, we do. We discussed, because that's how actually we found out. We had to find actually a local builder over here and discuss everything. Well, I mean, we checked with multiple builders and then we discussed it with them. And it was based on that recommendation when we worked out what the details that we had to submit the variance.
Thank you.
Anybody else?
Yeah, I'm a little confused here so if you move it 6 inches, you'll be 6 foot on one side and then 6.5 feet on the other side. I'm not sure.
I think what we're recommending, he actually gains a half a foot.
Exactly right. That's what I was.
So we were recommending you kind of center it there, because if you look with the setbacks, if
Get more
you
room
did
in it.
6 on either side, you would actually have a half extra foot, 6 inches, for what it's worth. And you would lose 1 foot on the 7-foot side. Whether that makes a difference trying to get a wheelchair and a path, 12 inches, I don't know.
To be honest with you, it's not my area of expertise. This is just from discussing with the builder and stuff and just finding out it's not like, this is actually my first rodeo.
That's fine. Yeah, I just, staff's recommendation, I think, gives you what you want, and actually a little bit more if you need it. It's just a matter of the placement of the house on the lot, not so much the size.
I think it might have also to do with like how the house will be located and everything else, mechanicals and stuff, because like even when I spoke to the builder, because they might also have their own reasons besides actually what we propose to them and ask them to do.
When looking at this photo here, will the entrance to the house be on the 7-foot side or the 5'5" side?
Actually, it's going to be on the entrance to the house is going to be on the 7-foot side because it'll be in the back. That's actually South Bay Drive. Yeah. So it's going to be on that side.
And
yeah, right there.
At the
right
back
there.
of the house. Okay.
Yes.
So then, I'm thinking about handicapped accessibility. That lends itself more to what my.
Actually, we haven't taken away the idea. It's just we're considering the financial impact of it, of having an elevator installed for her, like a small one that can take her up and down, because we're sure she's gonna enjoy the rooftop in there. So we haven't taken that out, but.
Just, I'm really trying to think about that 7 foot and the nature of the house being up and how that ramp would have to run, because it couldn't be a straight up. It almost has to be, over. And I'm wondering I'm questioning, is that the reason for to make that 7 feet?
I'm sorry, I didn't understand the question.
I'm wondering if the reason the plan that the builder drew up, he put the extra footage on the one side to accommodate the length of what that ramp would be. I mean,
it's totally possible, because that's where the ramp is going to be actually. Into the house.
And that's why I'm asking the question, because I've dealt with some issues where people are handicapped and they're trying to make their house accommodate a handicapped person, and although that wasn't, I worked
and
for
that
the doctors.
Totally could be, because most of the stuff for accessing the house, everything actually is going to be on that side, because on this side it's just going to be actually the kind of the driveway leading to the parking.
Yeah, so you come in from the rear, but then the ramp has to go, and because of how tall it goes,
so it needs to be
goes, and then it exchanges, and then you go up further. And that's why I'm inquiring if that's the reason for that, the builder suggesting the extra width because of the accessibility. But and that's within my line of thinking. But you don't know for sure.
I don't know for certain.
Okay. Well,
honestly.
thank you for saying
absolutely.
that. Okay. Anybody else? Thought. Okay. Well, thank you.
Thank you.
I was just noticing, and I don't want to get too far in the weeds here. I mean, if it's a handicap,
mind, I can definitely give the builder a call and try to get an answer to that.
Handicap ramps have to be 5 feet from the side property line. So if you were to put a handicap ramp wider than 2 feet on the 7-foot side, I mean, that's another variance.
Gotcha.
Because that's a requirement. So. I guess, you're going to ask for what you want with the 7 feet, but I don't know how that necessarily helps. I mean, as opposed to what staff recommended, but.
Sure. If the board doesn't mind, I can give him a call just to put that to rest and try to get a hold of him right now. I mean, I can just step outside if that's okay, and then come back if that's okay.
If you go and ask the builder and get that information, we'll be happy to hear it. But what they're saying, it's not going to make a difference because it's going to require, because of the wheelchair ramp, you'll require extra distance. So, but you're certainly, I don't usually, but if you find the information out as we're moving forward, I will allow you to submit that information to us. Okay.
Sure.
Thank you.
My pleasure.
No more questions, okay.
Okay, thank you.
Thank you.
Is there anyone here, else here that would like to give testimony in favor of this application? In favor or online? Anyone? Okay, no more testimony in favor. Does anyone want to give testimony in opposition to this application? Opposition in the room or online? Okay, so hearing no more testimony for or opposed this application, we declare
I want to hear from Mr. Townsend first.
Oh, sorry.
Well, was the applicant invited to get additional information that he could submit tonight?
Yeah, he was going to make a phone call to see if the builder would tell him
So
why.
can we move on to the next
And
public
without
hearing?
like closing.
So we won't
this.
close it, we'll just leave it. Okay, that's fine.
Okay, thank you.
Okay, so the last application tonight is A21-35, George Weaver. Is there someone here to represent the application here tonight? Great, thank you. Do an introduction here. This is A21-35, George Weaver. He's seeking a variance from the requirement that an accessory structure shall not be located in the front yard or front setback unless it is 100 feet from the front property line to build a pole building, and a second variance from the requirement that fences more than 4 feet in height cannot be placed in the front setback to place a 6-foot fence. This property is located at the intersection of Metz Drive and South State Street, north of Magnolia, Levy Court District 4th, zoning district RS1, single-family residential.
Before you just go any further, and so we don't interrupt more train of thought, the applicant from the last variance request is here. So if you want to step forward and tell us what you found out.
Sure.
So just for clarification for the record, what is being the person who is speaking now?
I just spoke to him actually, and there was actually a misunderstanding because we talked only over the phone, and he said they're actually fine with the recommendation of centering with the 6 foot on each side.
Okay, so if the recommendation of 6 on either side would be okay.
Will be okay, yes, absolutely.
Thank you so much for that information.
Thanks again.
Uh-huh.
Thank you.
Okay, so just for the recording.
Sure.
Because we changed here in the middle. And I just want to say that the person who just spoke was A2133.
Correct.
And that was just that one comment. He brought us some information. Just because as you're doing the minutes, that can be crazy. And now we need to close.
Okay, so now that's the end of the testimony for that. So based on that testimony, A21-33 is now closed.
Okay, so thank you.
No, thank you.
Thank you. So moving back to A21-35, we've already done the introduction. So this is the actual plan for both the fence and the location of the proposed pole building. You can see, first of all, the pole building will be 47.2 feet from the property line there to the closest corner. And then you can see the fence where it will be located is proposed, I believe, 1 foot from the actual property line. And you can see that there along State Street. Go to the next one. This is a picture of the property, the subject property. You can kind of visualize where that pole building is going to go. Go to the next slide, please, Jamie. Thank you. I believe those flags, I think there's even a better picture there to give you some idea, right, where that property line is. Hopefully the applicant can confirm that, or Nick can, just to give you some idea where that fence would sit in proximity to the road. Certainly visibility coming out of Metz Drive is a concern of staff, and hopefully we can address that. Again, there's those flags to give you some point of view. The pole building will be off to the right there. Again, there's those stakes to give you some idea where this fence might land. This is an aerial, obviously, before the house was constructed. It's been recently placed. And this is just a higher elevation of the subject site. Okay, if we could have someone come up, please, and let our attorney swear you in and give testimony for this particular application.
Good evening. Nick Patel, representing the seller via Elliott Surveying Corporation, 727 West Birdie Lane, Magnolia, Delaware.
Sir, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
If you would pull the microphone close to you, please.
There you go. Sorry. Okay. So as Scott recommended, wanted to kind of take you back just a little bit on the history of the property. The current owner did not have this custom built or had a say in where the house was located previous to. This was built. It was a spec home, and he purchased when it was 20 to 25 days from being completed. So in the process of it, the drive location, and if you can look with the setbacks the way they are, there really wasn't a lot of room for the builder to really adjust the location of the house as it is. It's literally 11 feet off the left property line, and it's 76 feet off the front line along South State Street. So I wanted to kind of point that out to show you why he's recommending or why we're proposing the pole barn to go where it is. With that 75-foot setback, when this lot was created years ago, I would say 30 plus years ago, the setback was only 25 feet. Over the years, it was increased to 35 feet. And when we finally got the property under contract and go to settlement, we got the final survey done, is when we found out about the 75 feet. So I wanted to point that out as we go along. But one of the biggest practical difficulty, if you look at the plan, you'll see there's a black line toward the back of the house that goes toward the back of the property. That's an actual sewer line, okay? And then along the back and the rear, it's kind of covered, but if you look at the back setback, which is, Jamie, if you can confirm that for me, is that a 40-foot backyard or 30-foot? I can't tell from here. To the actual building restriction line, I'm sorry. It is 30, yeah, you're right, I'm sorry. Yeah. Okay, so just short of that, you'll see that there's a green line where the blue line is outlined. That's actually a tree row. And it's in a conservation area, so no trees can be cut along that strip. And if you look at the pictures, you can't really tell from the actual pictures that they took, but there's also a 6.5 or 7 foot tall berm that's under that tree line. So there really is no way to push the building to the back. And we can push the building up and down along that property line all we want, but it would still encroach into the front yard setback. So this is really the ideal place for it. It's really the only place for it. There's only an 11-foot clearance on the left side, so you can't really go on the other side either. Driveway purposes, it's just impractical. So I wanted to kind of point all that out before. One of the things that Scott brought up in the introduction was visibility as you're pulling out into South State Street. That's one of the reasons why we located. So if you look at the dash line that kind of follows the driveway, and you see where it curves, and then all the way down. I'm sorry. If you go to the paved drive, yep, follow that down, and then towards South State Street, you'll see the dash line. I have the edge of pavement located, so really the corner of the pole building will actually be about 58 feet to the shoulder and 68 feet to the traffic line, the first traffic line. So there is plenty of room. Visibility will not be an issue. Neither will safety for anybody at the stop sign getting ready to turn left or right onto South State Street. With the fence, the blue line indicates where they would like to put the fence. Obviously, the fence was one of the biggest issues we had when speaking with the county. 4 foot is what's normally required. But a 4-foot fence really wouldn't provide the privacy that a homeowner would need, especially along a busy highway. But so the question came out to, does a 6-foot fence really affect traffic and the visibility of anybody going into traffic? But if you look, we have a 25-foot clearance from where they're stopping from where the fence would be to oncoming traffic. There is no visibility issues there as well. So we've physically located all of that before, as we prepared the plan. And when we proposed this, we took all of that into account before coming before you, asking for the variances.
Okay, any questions?
Yes. Can you go to the aerial? I just want to see what the development looks like, how much traffic is, how many lots are back in there, and how much the traffic flow is in and out of there.
Mr. Cusick, just as you're looking at that, the aerial's a little off as well. The property line is not as close to that shoulder as it shows on this aerial. It's another, I would, graphically, it's about another 15 to 20 feet further north. Just wanted to point that out.
So is this a dead-end street, or does that wrap around all into that?
That is a dead-end street, correct.
Okay.
Yeah.
There may be, maybe 10 lots in there?
I don't know the exact number, but you're really close with that number. And the first 3 lots, this is lot 1, lot 2, and lot 3, they were just recently built. They were all spec homes.
So I have a quick question.
Sure.
Not so much on the setback of the building, but on the height of the fence.
Mm-hmm.
Across the street, all those homes are on South State Street. I don't know that any of them, I can't tell from here, but have 6-foot fences for privacy. You mentioned being for privacy.
Correct. And I'll answer that. I mean, if is that the whole question? Did you have another? Okay.
Why you need a 6-foot fence all the way around when I don't think any of the others have it.
Sure.
And they also have the same issue of being on the busy highway.
Correct. And logically speaking, so when we looked at it, I know the gentleman directly across the street. He's also a client of mine. The way that his house facing, that's the front yard. So
say it again.
The way that his house is facing across the street, his house is facing South State Street. So that's his front yard. So you really, 99% of the houses wouldn't want a 6-foot fence along the front of their yard. In this instant, even though they're calling it a front yard setback off of South State Street, it's really his side yard. It's not the front. So that's why the 6-foot privacy, plus with him, with the children and the dog, a 4-foot tall fence, especially with people walking up and down the street, believe it or not, it's just 4 foot is not really giving much visible privacy and or safety as well.
Okay, so ingress egress from your property is on that side street and then out to State Street.
Correct. Yeah.
So your driveway.
So can you go back to
Yeah, can we see the
graph? The one with it. There you go. Thank you.
That helps. I'm just trying to see where your driveway does not come out onto State Street. It comes out onto
Metz Drive.
Metz.
Correct.
And okay.
Yep.
And then can you tell me what the use of the pole building is for?
It's for storage of, 2 things, storage and, just general storage for the home and as well as vehicle storage. They have, there is a 2-car garage, but this is a military family. They have 3 vehicles. They need another access to, for vehicle storage and as well as home storage because there is none of these lots were approved with basements. So no basements are, one of the things that they need is storage for the family. And we thought about sheds in the back, but with the sewer line where it is, with the well where it is, a shed really wouldn't accomplish much but take up their full backyard. Because that berm and that tree line literally take up, it actually continues all the way up along the adjoining lots.
Can I ask a question of the staff?
Sure.
So along South State Street, that is permitted, 6 foot would be permitted there?
When it's in, a 4 foot can go right to the property line in every direction. If you go above 4 feet, it cannot be in the front setback. And because South State Street is a major road, it has a 75-foot front setback.
And hence the problem. If it was a shorter setback, they would have no problem. The variance request wouldn't be as bad.
Understood. So the other houses that are along the Metz Drive that are facing the same way yours are,
correct.
But they don't have a 6 foot in their front, which is also considered a front, right?
Well, they don't have fences, but at that point, like, they wouldn't bring it all the way to the front property line. They would just stop it at the front of the house, like we would, and like we're also proposing. It's stopping literally at the front of the home.
Right, this is a corner lot with two fronts. The
Yeah.
South State Street is a 75-foot, and then the other front setback on Metz is
30, I believe it's
I can't
also
see
30.
the plan. Is it?
It's 30. Yeah.
Okay,
So
thank
there-
you. It's 30.
Problem because you have, there's two fronts to this property. So if it were a sideline, they wouldn't have to be here. Okay.
Yeah, their side is a front.
Okay.
And we asked about the setback if the 75-foot was a, but it's just because of over the years that the lots have been vacant for so long that because no permit was ever applied for, nothing was ever built, nothing could ever get grandfathered in. So from 25 feet front yard, 35 feet front yard, and now it's 75 foot front yard. Oh, sorry about that, Mr. Townsend.
Yeah, I can see your 6 foot wanting to be along South State Street. It's just the one that bothers me a little bit is from the garage you're building, the building you're building over to that South State Street. Why that couldn't be 4 feet and aesthetically would look a lot better within the.
Yeah. And again, like I said, it's a 4 foot fence does, as far as just privacy, a 4 foot fence really does nothing. That comes up to here. So a 6 foot provides quite a bit of privacy, especially if you're in the backyard with your family, kids, So a 6 foot fence would normally be allowed. It's just that in this situation, because that setback is preventing them from doing the 6 foot, that's why they figured they would like to ask for it. Yeah. So.
Yes, I have a question for staff. Where is that proposed location that you guys were suggesting in the rear corner of the lot? Where would that be on that graphic?
Yeah, Mr. Jenkins, I think it's back where it says BRL line in that back left corner in that area. Yes, thank you, Jamie.
So, and I can answer to that as well. If a pole barn or a shed or anything like that was to build back there, with the sewer line where it is, you would have to have a driveway either wrap around to the right of the house and all the way back to it, or you would have to try to squeeze 10 foot, because remember from the left side to the house, it's only 11 foot clearance. So imagine, but then they'd have to wrap the driveway around the front of their house. So you have two issues there. Practicality, it's just not available. They would lose almost all of their backyard to that. So no future decks, because there's no deck on the property currently. No decks, no pool, nothing. They wouldn't have anything available. And then the last thing is, we've talked about it here quite a bit, is impervious coverage. Imagine having to pave or put all that driveway to go back there. It would definitely be a hardship.
Just to follow up on that same graphic, where is that septic line?
Sorry. So if you see there's a toward, I don't know if they can put the arrow on there, but it's toward the back of the house, and it's that line, the dash line that goes to the back. Yeah, that's the sewer line. Yeah, yep.
Anybody else? Okay, Mr. Townsend.
Just on that question about a 4 foot fence versus a 6 foot fence in the front yard, did the staff, and forgive me if this is addressed in the report, but does that present, the justification for a 4 foot fence versus a 6 foot fence is public safety. If you're leaving Metz heading towards South State Street, is a 6 foot fence going to block your view of oncoming traffic where a 4 foot fence wouldn't? Is that a consideration?
Yes, Mr. Townsend. Obviously the code just stipulates that a fence taller than 4 feet can't be in the front setback. But in addition to the code requirement, we also felt, that could be a potential visibility issue for those pulling out of Metz. I think Mr. Patel thinks, and his client think that isn't a problem, and they tried to speak to that tonight.
And I can spell it out a little bit better because the arrow wasn't pointing in the correct area, but I can kind of detail that a little bit more if need be. So.
Some of the previous photographs, if you would, Jamie, I think when I went out and shot it, I tried to show that. Right, so here you are pulling out of Metz, and if Nick could speak to, are those stakes where the property line is,
yes,
Nick?
So that
right.
Exactly. So that red stake, if you hold that arrow right where that, so that would be, so a foot left of that is where the fence line would go. If you see right here, just at the bottom of the picture, you see that manhole cover. The stop sign is 3 foot right of that on the other side. So if a car pulls up to the stop sign like they're supposed to, there is nothing blocking them from the fence to the road. It's completely visible. And that's why, so when you go back to my plan, that's why I physically located the edge of the pavement to show exactly where that would go.
So for, you know, just for the record,
Sure.
because you're explaining something that everybody can see, there absolutely is no, you can put almost an entire car up to the stop sign to look.
A full car and a half.
Yeah, a car and a half.
Yes.
And so there is no visibility issue, which is really why that is part of the code. Is
correct.
Because of it. Okay. Just for clarification.
Right.
Thank you.
Mm-hmm.
Anybody else? Okay. Thank you.
Okay, I appreciate it. Thank you, guys.
Thank you, Nick. Was there anyone else in the room that would like to speak in favor of this application or online in favor of this application? Does Mr. Weaver want to speak, or?
No, I was just going to say, if you do have a question for the seller, the owner, he's here.
Yeah.
So.
Does anybody have a question for Mr. Weaver? The property owner's here. No, sounds like no.
Okay, it doesn't sound like any more testimony for the application. Does anyone have any testimony in opposition to this application, either in the room or online?
Hang on, we have. Oh, want to break? Okay.
Okay, we're good. Okay, it doesn't look like there's any more testimony for or against. Based on that, 821-35 for George Weaver, the public hearing is now closed. Thank you.
Okay, so we've had a request for a short break. So let's take a 5-minute break, and we'll see you all back. Okay, so are you all ready? Are you good? Okay. Okay, so I'm going to call to order the business meeting of the Board of Adjustment for September 16th, 2021. Will you please call the roll?
Yes, Ms. Hudson.
Here.
Thank you. Mr. Saunders. Mr. Jenkins.
Here.
Mr. Cusick.
Here.
Mr. Crossan.
Here.
And Ms. Stenny.
Here.
Roll shows 5 present, 1 absent. We have a quorum.
Thank you. So the next item on the agenda is election of a vice chairperson. Mr. Carter has left us to become part of the Regional Planning Committee, and I believe, per conversation last month, that there's some movement happening about a replacement, but that hasn't happened yet. But at this point, and I kept thinking tonight, like if I don't come to a meeting, who chairs the meeting? So at this point, obviously, the planners have fought ahead as well, so we need to, among us, take a vote on who would be, possibly be a vice chair. So at that point, I guess what we need to do is take nominations first and then just proceed with a vote. So anybody have a nomination?
Yes, I'd like to nominate Mr. Crossan.
I'm going to have to politely decline. I'm not actually sure how much longer I'm going to be on the board. Thank you, though.
No more bad news, please, tonight. Thank you. Okay, so we do.
I will do it if just to move this meeting along.
Okay. All right. So,
But don't ever be absent.
So we have a nomination for Mr. Cusick, and I'm not hearing anything from Ms. Hudson. So I'm just.
I'm sorry. Who made that nomination?
Second.
Well, we haven't gotten the nomination. We just had a person suggest that they would be willing to make the sacrifice.
Thank you.
And
Appreciate
I would be
it.
willing to become the vice chair as well. Just throwing that out there. So, okay. So at this point, then, I need a nomination, and we have one willing body in the room here.
I would like to nominate Mr. Cusick for the position of vice chair.
Okay, you have a nomination. Okay, a nomination, a second. Thank you. So I think at this point we can say all in favor?
Aye.
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 Any nays? Hearing none. Congratulations, Mr. Cusick.
Or condolences, as it may be.
And now you get to sit next to me. Sometimes I'll share my little hammer. Okay, moving on. So we now have elected a vice chair. First matter of business is approval of the minutes from last month's meeting, which would be August, what did I just do with them? The August 19th, 2021 meeting. So I need a motion and a second on the minutes.
Crossan, I'll make a motion to approve the August 19, 2021 minutes as presented.
I'll second that motion.
A motion and a second. All in favor?
Aye.
Aye.
I was absent.
Mr. Cusick. Okay, so we have 2 members who are absent and won't be voting. So at this point, we only have 3 people, but, so Mr. Townsend, is that okay? There were only 3 among us here last month.
So when it comes to granting variances, there's I believe you need 4, but when it comes to matters such as this, a majority of the quorum would be sufficient to proceed.
Okay, so we do have a majority, so therefore the minutes from August 19th are hereby approved. Notice of decisions, and those decisions are A21, 22 through, I'm looking, I think it's, I usually write through A21, 28. And so I will need a motion for those as well. And those were the July 15th, 21 meeting.
Crossan, I'll make a motion to approve the decisions from the July 15, 2021 meeting that included applications A21 through A28.
We have a motion. We need a second.
I'll second that motion.
We have a motion and a second. All in favor? Aye.
Aye.
Any nays?
Aye.
I would be abstaining from the July 15th notice of decision approval.
Okay, so we have 1 abstaining and aye for the majority. So the notices of decision are hereby approved. We have no old business, and we have a lot of new business, and not everybody remained, so we could just maybe go by in order based on who's here, and then.
Correct. I believe the first one in line who is still here is Delaware Electric Co-op, A21-31.
Okay.
I make that we approve A-21-31 based off staff recommendation and public testimony.
I'll second that motion.
Did I jump the gun? Okay.
Okay, we have a motion and a second. So when you're ready, call the roll, please.
Okay, thank you. Mr. Crossan?
I vote yes to approve A21-31 based on the staff's recommendations and also the fact that this particular the removal of the requirement would not negatively affect any other properties since there's already electrical components in that location. And the fact that if it didn't have the variance, there could be danger to surrounding properties with potential electric arcing between equipment and the control building.
Great, thank you. Mr. Cusick?
I vote yes to application A21-31 per staff recommendation and as well as a safety factor that Mr. Crossan just referenced.
Great, thank you. Mr. Jenkins?
Yes, I vote in support of application A21-31 because of the potential hazard of the building that they're proposing.
Thank you. Ms. Hudson?
I vote for A-21-31 based off my motion.
And Mrs. Denny?
I'm going to vote yes for application A2131. I think that the exceptional practical difficulty certainly has been proven based on the fact that the testimony said that there's a safety hazard due to arcing. So yes.
Thank you. So for application A21-31, we have 5 yeas and no nays.
Okay, so having received unanimous positive votes, application A2131 is hereby approved.
Okay, great. Oh, there's Mr. Miskowski. I didn't see him behind the podium. So next up is A21-32, Frank and Sheila Miskowski.
Okay, do we have any comments or feelings, suggestions, or a motion here?
Mr. Cusick, I believe when you were asking the gentleman during that about removing some pavers to help take away a little bit of the impervious surface that's currently overage, and he said he agreed that that would be feasible.
Yeah, so it was about 100 square feet. So I put it at 320 square feet of the proposed additional, and I'm not sure what that percentage is, but.
And I would point out one other thing in the staff report. Even without the covering of the deck, this property is already over the impervious. So I think at a minimum, staff recommended at least approving the existing impervious on site now. Just something to consider.
No, I feel like there's an awful lot. I mean, we're physically seeing a lot of water already on that property where we come to impervious soil. I mean, and one thought is, well, you know, as you view there, you think, well, there's plenty of places for it to go, but that really isn't a stream there that the water is falling into. It's just really, you know, like a hedgerow of, you know, of planting. So anyway, just wanted to add to that. And I have seen a lot of these awnings, and you know, I do think that, and of course they are meant to be opened when you need them and closed when you don't, but at any rate, so I just want to point that out. You know, I'm not sure that I think that that idea could be eliminated. But anyway, so that said, any other comments or a motion?
Oh, I just would make a comment that during the testimony I was trying to get some wiggle room out of the applicant on, you know, shortening that just so that we could stay within the code the best possible. It just didn't seem like there was any wiggle room there on that.
No, and I do know that, you know, certainly that would be helpful. You know, I agree, you know, there no wiggle room. So, still looking for a motion, maybe? Okay, so let's just go back a minute. I'm looking for my papers have got a little discombobulated here, and I'm looking for what would have been the staff recommendation, and I now have it in my hand. So, I mean, we deny it. They're not
setback, but then Legalize the existing.
the existing, but not any additional impervious soil. So they're saying, don't add any more. They're telling us to deny adding any more, but they would hope that we would, or are suggesting that we would approve what's there. So that said, and you know, I in my mind, I'm just going to say this, I'm searching for an exceptional practical difficulty, and that I didn't just feel like I found one, but at any rate, so I still am in need of a motion, somebody.
So in your opinion, you wouldn't consider like that blue line stream and wetlands and that slope, that severe slope, any possible exceptional practical difficulty?
As a reason why you can't build a deck? Oh, because of the impervious
Yes.
soil?
It seems to me that argument goes to that third consideration, which is whether there's any harm that results from the relief that's granted. And the existence of the unusable property might support a conclusion that there would be limited harm, but it doesn't go to the question of what is the exceptional practical difficulty here, which was expressed by the applicant in terms of a desire for shade and to protect his porch furniture and stuff like that.
So we're really, I mean, we've got a couple things happening here. We've got the back setback, and we have the impervious soil. And again, you know, at the request of staff, we need to at least address the existing. But, and the question is, what do you feel about the setback? Now, will you flash I'm sorry to ask all this, but would you show us the rear yard again?
And I think I would add the area directly behind this lot is and Mr. Miskowski can maybe help out. I think that is common area to the HOA, so that will not be built on, so there will not be impacted people back there.
This picture, and I see the house behind it, that's common area?
To the left,
The
with the
side
wooded
yard,
area.
okay.
Yeah, the aerial
We're
might show
talking
it as...
about where we're seeing the woods. Okay. Okay. Well, looking for a motion.
Staff, if you take
For
off.
A-21.
A2132.
Excuse me.
You're breaking up so badly.
No, I'm stopping because I heard somebody else speak.
Oh, I'm sorry. Go ahead.
So I was making a motion that we approve A-21-32 based off the nature of the zone where the property lies does not change. The character and the use of the immediate facility does not change, and the removal of the restriction does not seriously affect neighboring properties.
Okay, so it's your desire to lump them all together, both the impervious soil as well as the setback?
Yes.
Of course.
Mr. Townsend, if that was to be if the motion was to be, how would we change that if we still want it, if it was to be approved, but with the removal of the?
It'll be a modified approval.
So what you have now is a motion without a second. So I think the first step is to determine whether you can get a second. It could be that somebody wants to propose another motion and there's a majority of people here who are ready to support that. So I don't know the answer, but let's first ask if there's a second to this motion.
So if we get a second, if we don't, then the motion fails. Okay, so we have a motion.
So I was going to ask the staff, what percentage, so if you take 100 square foot off that impervious coverage, what percentage do we need to be at? Is it 40?
To approve the roof over the deck, removing the 100 square feet of patio, that would be 41%. So what I did is the existing of 3,789 square feet, plus the additional for the roof over the deck of 420, minus the 100 square feet for the existing pavered patio. That would bring it down to 4,109 square feet of impervious, and that is equivalent to 41%.
Thank you.
Okay, so do we have a second?
I hadn't called for it because he had a question. So we're looking for a second on the motion to approve both the setback and the impervious. So hearing no second, the motion has failed. And so now there would be an opportunity if someone chose to make yet another motion.
I'll make a motion for modified approval to application 821-32 to allow the applicant to go a maximum of 41% impervious surface coverage, and also to approve the 25-foot rear setback. The reason is, for one, he did the due diligence with his neighbors, no opposition there, so it's not going to affect the neighboring properties. The open space behind it, property looks like it's well drained towards that open space, so I don't see any runoff issues, and I don't see any impact on the neighboring properties. And I think the hardship is there, as I feel like the deck, to be efficient, to be able to use it as efficient as possible, if there's no, as the testimony said, there's no shade in that area, I think a shade structure will be helpful.
I'll second that.
Thank you. If I may ask a question, Mr. Kuzik, so you're making a motion to approve the 19-foot setback in place of the required 25. Just
yes. Sorry. Yep.
Great. Thank you. And thank you, Mr. Jenkins was the second.
Okay, so we have a motion and second, and when you're ready, call the vote.
Okay, Mr. Crossan.
I vote yes to approve A21, the modified approval of A2132. I do believe that the open space and behind the property is very large and certainly would accommodate any runoff. And the fact that the homeowner has offered to reduce a little bit of the existing impervious area that's behind the house.
Thank you. Ms. Hudson.
I had a question. Are we doing the 35% set of the impervious, or is it, did you say 35 or 39?
41.
41, correct. He's going to mitigate somewhat, so instead of the 42, it drops to 41 by him removing a brick patio or paved patio.
Okay. Then for A-21-32, I vote to approve the modified approval of the 19-foot setback and the 41% impervious ground surface. And I vote to approve it because I believe the community woods and the back of the house would allow for excess runoff to go, and the character and the immediate facility does not change.
Thank you, Ms. Hudson. Mr. Jenkins.
I vote yes in support of application 21-32, based upon the modified motion before us and the fact that the applicant has made some effort. He didn't meet us half.
Thank you, Mr. Jenkins. Mr. Kusick.
I vote yes per my motion.
And Ms. Stenny.
Okay, I'm jump on the other side of the fence, I guess. I'm gonna vote to approve. I'm kind of searching a little bit for an exceptional practical difficulty here, but at any rate, I want to be very clear that in no way as this vote should be considered precedence for this, because the uniqueness is that it appears as though there's a lot of drainage there within that wooded area. So, yes.
Okay, thank you, Ms. Stenny. On a motion on A21-32 for a modified approval to grant a 41% impervious surface and a 19-foot rear setback, we have 5 yeas and no nays.
Having received unanimous positive votes, application A2132 is approved with modifications.
Okay, the next application, A21-33, is now up on the screen. This is for the side setbacks to build a residence.
Okay, yeah. Any discussion or a motion?
Yes, Crossan, I'll make a motion for a modified approval that requires the new dwelling to be centered on the lot so it's no closer than 6 feet on either side, as opposed to the 7 foot and 5.5, which was originally asked for, as in the applicant expressed okay with the 6 foot setback on each side.
I'll second that motion.
Motion is second. When you're ready, call the roll.
Okay, thank you. Ms. Hudson.
For A-21-33, I vote to approve a modified approval requiring the new dwelling be centered on the lot so that is no closer than 6 feet to either side of the property based off the staff recommendation.
Thank you. Mr. Kusick.
I vote yes to application 821-33 for the modified approval for the lot to be no closer than 6 feet to either side property line per staff recommendation, and then as well as the practical difficulty that the applicant addressed with the family's wheelchair need.
Thank you. Mr. Jenkins.
I vote yes in support of application A21-33, the modified approval to center the house based on the testimony of the applicants and the special needs requested.
Thank you. Mr. Crossan.
I vote yes on the modified approval based on my modified motion.
Thank you. Ms. Stenny.
I'm going to vote yes on this application. The exceptional practical difficulty, and not to set a precedence here, it very typical with this particular area because of the water, the narrownesses of the lots, and so I'm going to vote yes because it's pretty much the best that they can do on these lots.
Okay, thank you, Ms. Stenny. Okay, on a motion for a modified approval on A21-33 to be no closer than 6 feet on either side, we have 5 yeas and no nays.
Having received unanimous positive votes, application A21-33 is hereby approved with a modified result of a 6-foot setback on either side of the property.
Okay, and the last one this evening is A21-35, George Weaver. This is 2 variance requests, one for a fence and one for a pole building.
Okay, I just want to ask a question. Did we do Mr. Brown? Oh, we tabled Mr. Brown. Oh, God, losing my mind again. Okay, good enough. Let's go. Looking for discussion or a motion.
I'll make a motion to approve application A21-35 to allow the pole building 47.2 feet from the front property line off South State Street, as well as the 6-foot vinyl fence, which will be 1 foot from the front property line. The reason is the uniqueness of the lot. I think the hardship of the pole building is the backyard where the sewer is. You have the well there, so I think anywhere they really put except that back corner, which will take away from the backyard, they'll need a variance. And this particular spot, I think, is the most practical spot for it. For the fence, obviously the safety factor, but I think per the testimony, he addressed the safety factor that we have enough clearance from the fence to the edge of pavement.
I'll second that motion.
Okay, so we have a motion, a second. All in favor? Oh, I'm sorry. Call the roll.
Thank you. Mr. Carlson.
Excuse me. Vote yes to A2135. The homeowner's representative spent a lot of time checking and double checking to be sure there'd be no traffic issues for people pulling out onto South State Street, and that the several other items on the property really wouldn't allow for the pole building to be placed anywhere else other than where it is.
Thank you. Ms. Hudson.
For A-21-35, I vote to approve based off the exceptional practical difficulty of having that conservation tree line, the sewer line running through the back of the yard, and the unique aspect of this property having 2 fronts on it. I believe that the exceptional practical difficulty is there, and it would be a financial burden to have to relocate everything to fit within the setbacks.
Thank you, Ms. Hudson. Mr. Jenkins.
I vote yes in support of application A21-35. Based upon the testimony tonight, he really demonstrated and proved there is an exceptional practical difficulty with this particular parcel. So for that reason, I'm in support.
Thank you. Mr. Cusick.
I vote yes per my motion.
And Mrs. Denny.
I'm going to vote yes. I definitely feel that there's an exceptional practical difficulty that's mostly created by the double-fronted lot. And testimony tonight showed that there is more than enough visibility in egress from onto Metz and from Metz onto State. So, as far as the fence goes, and I with the sewer and all the other thing that's going on there, I think it is the only really practical place for them to put the pole building. So yes.
Okay. Thank you, Ms. Denny. So for application A21-35, we have a motion to approve the variance requests, both requests as requested. We have 5 yeas and 0 nays.
Having received unanimous positive votes, application A2135 is hereby approved.
Okay, that's the end of the applications for this evening.
Okay, so I'm looking for a motion to adjourn.
I make a motion to adjourn this meeting.
Okay, motion to adjourn, got a second?
Second.
All in favor? Aye. Good night, nurse.
Thanks, Morgan.
I just had to say something, honestly. My experience, I've been through many counties, and this is the friendliest county actually I've ever experienced. I live in Virginia, and I have experience with Fairfax County, Arlington County, and I'm not talking about the board, honestly. It started from my first phone call throughout, and even throughout the security coming here 3 times, everybody's just friendly, so just wanted to say thank you.
Thank you.
I even told the first person, I'm like, do you guys put something in the water? Thanks again. Delaware.
Welcome to Delaware.
And that's one of the reasons actually why I appreciate it. Thank you.